Should I admit him?
I just did.
Okay. There's Dave. Hi, Dave.
Molly, you've switched.
Gary and Karen, can you hear us?
Yes, I can hear you just fine.
Oh, okay, great. On behalf of NYSTAR and the New York State Science and Technology Law Center, we're happy to welcome you to Ask the Expert, and the experts are the Innovation Law Center, which is an educational and research program at the Syracuse University College of Law. I'm Molly Zimmerman, and we are holding these sessions on the third Thursday of the month at noon for any type of questions people have about the commercialization process. And before we get started, we're going to ask everybody to introduce themselves, and we'll start with our director, Jack Rudnick.
Hi, that's me. Welcome. Glad to have you here. I'm the director of the program. We are formerly general counsel with Welsh Allen and other large companies. Have been with the program. I've been teaching part-time for 20 years, but have been with the program the last 8. The program used to actually, we gave projects from Welsh Allen, but our mission is to try to help tech companies, startup tech companies in New York State in particular, to find a path from the lab to the market.
Dom?
Okay, my name is Dom Dana. I worked with Jack and Dave at Welch Allen for many years, medical company. I was in research and development, and we worked on all sorts of new innovations and a few breakthrough innovations, actually. And my background is in chemistry and electrical engineering and mechanical engineering also, and all sorts of, I like all sorts of technologies. I guess, Rod, I think that's about it.
Brian?
Sorry, I had to unmute there. Good afternoon, Gary and all. My name is Brian Gerling. Actually, I'm a graduate of the ILC program many years ago. I'm a practicing attorney here in town with Bond, Chinnick and King, and I've been an adjunct faculty member with the center for about a year and a half, almost 2 years now.
Dave?
Yeah, Dave Eilers. I'm a faculty member both in the Whitman School of Management as well as the Innovation Law Center. My background is in healthcare. I've worked for 3 healthcare companies, some of which helped me see healthcare in about 50 countries around the globe. In addition to my academics, also do some work with the Launch New York Seed Fund and the National Science Foundation I-Corps program. Again, just to help get across the valley of death, that, from basic research to tech commercialization.
Thank you. Carly?
Hi, my name's Carly Signer. I'm the program coordinator here. I don't have a background in law, but I have a background in journalism, so I manage the side of the center. I'm also almost done. Oh, this is my last semester as a master's student in higher education.
And Caitlin?
Hi, my name's Caitlin Crowbar, and I'm a third-year law student at Syracuse, and I'm also a senior research associate with the Innovation Law Center. So I took the course, and now I kind of help teach it and get with all the kids that are in it now. And I have a background in chemistry.
So Gary, this is our kickoff and we would love to hear your question. And we are also prepared to talk about different resources the center has, if you're just tuning in to see what we have to say.
Yeah, I was just kind of tuning in to listen, really. I'm a meteorologist with a True Weather Solutions who've worked out of the tech bar. We make software and stuff mainly for the UAS industry and building some new things. And I was just kind of curious because I know we're not too deep into the intellectual property type stuff. So I'm just kind of looking to pick up
You're
on it.
cutting in and out. The last thing I heard was you're not too deep into the intellectual property.
Yeah, we're not too deep into that. I was just kind of curious, as to what I might learn here. Being that we're building some new software and some connections and APIs.
Well, maybe I could just talk generally about tech commercialization and the challenges that Gary's going to have in a couple of the areas he's talked about. But many people.
Hey. Jack, just 1 second before you start in. Gary, it's Brian Gerling. How's Don? I worked with Don Birchoff. I've done some legal work for New Air. We've also done some work with Talus and Frank Mattis. But I've met Don many a time. How's he doing?
He's good. He's good. I'm sure right now he's talking to somebody. He never. Somebody's getting their ear chewed off for sure. Yeah.
I'm glad you led with that. I wasn't going to say anything, but he.
If you look at them, you know what I'm talking about.
Oh yeah, he's loves a chat. I told him he ought to be a talk show radio host.
Well, Brian, why don't you talk about tech commercialization? If you know Gary, then that's good.
Yeah, so Gary, essentially what we would do here, so if you've got early stage technology, we do a variety of things. The first of which is provide a patent landscape. So if you had a technology, we'd sit down with you, get an understanding of the technology under an NDA, of course, and then we get together with the students and we'd run a patent landscape search. So that is comprised of two things. One is a patentability study, and the other one would be the other side of the coin is a freedom to operate study. So the patentability study kind of gives you some insight into whether or not you might be able to secure patent protection. And how we go about doing that is much like what a patent attorney would do or a patent examiner at the Patent and Trademark Office would do, is we conduct research into existing patents, abandoned patents, expired patents, as well as other references and literature that's out there in the public domain, all of which would be used against or used by the patent examiner, rather, against you in the prosecution of your patent. So we kind of do a lot of the legwork that's necessary for you and Don and the remainder of the management team to make an assessment on, what's our challenges to securing patent protection for this particular technology. And the flip side of the other side of that coin is what's called freedom to operate. So in the event that it's a crowded field, there's a lot of patents on this particular technology. Not saying that there is in your case. It's just there could be issues that arise under the search. We also provide what's called a freedom to operate study, which is so if you're not able to secure patent protection, is there another patent out there that may preclude me from practicing our invention in terms of potential infringement? So we provide that analysis as well. And then once we have the IP kind of figured out, for lack of a better term, we then provide what's called a market study. So who's your competitors, who's your potential partners, what's the market cap for that particular technology, for that particular space. So it's kind of a soup to nuts report that we can provide. And many early stage companies find it highly valuable because it's essentially a packet of information that can be supplied to potential investors, or at least discussed with potential investors, to show that you're really on the ball and that you've researched your patentability avenues and also your market opportunity. So that's kind of a gist of or summary of the report that we can provide. There's obviously nuanced well, advice is the wrong term, but other forms of research we can provide. But that's essentially the backdrop. So anything else anyone on the team wants to add?
Well, I just wanted to kind of bring it together a little bit, because the people that were introduced, and I just say someone who wasn't here for the introduction, is you have the combination for you to get your tech to the market. We do preliminary research for your benefit in 3 areas: the business, the legal, and the tech. So you've got engineers, you got legal, and you got the business. So that's what we are. And we bring those 3 disciplines in together to assess and analyze your technology and how it could get from the market. But any one of those, as if you say, well, I've got my patent, I've got this, and you want a particular, well, what's my path to the market? What's my go-to-market strategy? We can do that. So understand that we're not practicing law per se, but we're doing research for you in these 3 critical areas. You need information on how you're going to get your tech to the market. We have a model. You don't know what you don't know, and that's what we're here to find out for you.
I've put our backgrounds in the chat box, a link to our backgrounds, and there's also a link to our guidebooks. Those areas, over the years, this program has been in existence for 30 years. In fact, Brian's a graduate of it. We try to come up with guidebooks that will be helpful to people. We do about 60 projects a year that are tailored to individual startups or inventors or researchers. But in addition to a grant from NYSTAR, we try to provide other means for people to get information about this commercialization process. Carolyn, did you have a specific question?
I did not.
And that's fine. I just wanted to give you the opportunity.
I appreciate that. No, I really was just interested in kind of gaining more of an overview.
Well, one of the ideas I had was to maybe go through some of the guidebooks, because they address certain issues that come up fairly frequently. I could start perhaps with the Founders Agreement Guidebook, which is a very new one. And you might say, well, lots of startups don't have a Founders Agreement. Why do you need one? And the point to a Founders Agreement is to make sure, when you have a number of people who are basically vetting the feasibility of a new technology, that there's protection for the intellectual property. Because if you're developing the technology and you're coming up with prototypes and you're exploring markets, you're maybe coming up with different designs, if there isn't an agreement that all of that intellectual property will be assigned to the business entity, whatever it is, it will be jointly owned and can be jointly exploited or licensed or sold, which essentially will render it valueless, because anyone that's going to want to invest in it will want to know that you have full rights to the intellectual property. So all of that is explained in the Founders Agreement Guidebook. And then, I don't know, would one of you like to talk about one of the other guidebooks?
Well, I want to go to the Founders Agreement, and we find many cases where people have brains and offer the tech, and some people have cash, and they're offering that to get the thing started, or they just have connections. But if you don't have a Founders Agreement, it all gets screwed up, and enough where your potentially successful startup was just going to fall apart. And that's unfortunate. So founders agreement is a good place to start. When you look at technology, many of our clients are brilliant people. They're all brilliant people. They're great people, really smart, but they don't really know how they sit. They know that their postdoc work or that their invention is what they have, but there's many things out there and they think that they've got a big idea, and they might, but getting that idea from the lab to the market is challenging and expensive, and perhaps very often is the case is to get a patent on that technology and then license it, partner with big companies, partner with the companies that are already in that line of business. So for example, when I was at Welsh Allen, we had a distribution network. We were all set. We knew if Dom invented a medical device, we knew it could go through our path. But we also invented, Dom in particular, invented technology that had applications in defense and applications in barcode, applications that had nothing to do with medical, but the technology was there. So we would partner or form a separate company and find another way to get it to the market. So licensing, our guide on licensing is there because that might be your commercialization strategy. You've got a patent or patents, a product, and you can't afford to make it. It's too expensive to manufacture. You don't want to go to China, so you license the technology to someone who has that access to the market and has that manufacturing capability. You don't get 100% of it, of course, but 100% of nothing is nothing. And so at least this way you get a piece of the action, or in fact sell your technology to somebody. So commercialization is not necessarily I invent, I make, and I sell. That's very hard. It can be done, but it's hard. And big companies seem to have a monopoly on that. But you as an individual inventor could do it, but you do it through licensing. So we offer a guidebook on licensing, because you have to, even at the very early stage, that's when the big mistakes are made, at the early stage. And in licensing, our guidebook would help steer you into the things you need to think about. And you don't need to be a lawyer to do it. You can read it, understand, and say, yeah, this makes sense. And then when you're ready, you might need to get an attorney if you're going to license out. But in the meantime, we're just trying to make people like yourself, or entrepreneurs, early stage inventors, aware of the trappings. So that we had a seminar, Dave, what was it the other day, last month? Big mistakes small companies make, I think is what it was.
Yeah, for the MedTech Association. Carolyn, do you want to introduce your technology, or are you an academic researcher, or what's your interest in learning more about innovation law and tech commercialization?
Well,
Nothing proprietary.
Of course. I have a few ideas, and I tend to spend my lunch hour learning new things. So this was today's new thing to learn.
Oh, good for you.
I may not do anything with this, once I do a little more exploration into it, then again, maybe I will. But I do like learning, and I like learning specifically different ways that people are able to go into business for themselves. I spent nearly almost 20 years working with micro enterprises and startups. So I really enjoy learning as much as I can about the process and just kind of filling in the blanks that I don't know about.
Good. Well, you're wise to do your research ahead of time. That's what we do. You're in the right place.
Well, thank you. It sounds like I am.
One of the guidebooks we don't have yet, that now that Dave is a professor at Whitman and in our program, and now he's newly with us on a longer, or what would you say?
More committed basis.
Right. So I want to tap him to work with the students on a guidebook on what you need to know about market research for startups. And maybe you could talk about that a little, Dave.
Yeah, so the good thing about the Innovation Law Center is, being an academic institution, we have access to some really great databases that would cost an outside entity thousands of dollars. But, if there's a chapter in that research study, we can obviously extract from that and get some insights. And again, it's all about due diligence and de-risking your idea from the market perspective, the patent perspective, the science. It's got to be desirable to the market. It's got to be feasible from a technical point of view, and it's got to be sustainable as a business. So that's, the IP research will help you exclude others. The freedom to operate research will help you have access to a market. So there's ways to look at that and break it down so that you can get outside investment. What's the total available market? What's the service addressable market? And where would you start? Most people say, oh, this is $1 billion market and I'm projected to get 10% of a very large market. Well, it doesn't usually work top down like that. It usually works bottom up. So you have to have a starting point, you have to have pilot customers, and then grow a sustainable business from there. So we can help you roadmap where you start and where you could finish, what you might be able to license with the databases we have access to.
I'd just like to throw in that
Smart researchers.
we have
Go ahead.
expertise, but the most important thing is, and as David alluded, is the experience. So that even if, so early stage technology, a device or a process perhaps, but someone like Don Dana can tell you, can you make this thing? Is it physically possible to make that device? And if so, can it be made at a price or a cost which allows you to make a profit at it? Dom, you had something a while ago. I mean, it was almost like what they call a Rube Goldberg. It was all kinds of stuff, but there was never a way that it ever could be made efficiently.
I always tell people that they really should make a prototype before they go too far, even if it's crude, because you really need to know if it really is going to work. Many patents are paper patents, where they come up with an idea, they draw it up, and they maybe never have made it or developed it to the point where it could be made in production. So, and it's amazing how many people haven't made any sort of prototype to really see if their idea was feasible. So that's one of the things that we go over with the clients. And if they haven't, then we try to get them. And usually it's a money issue. They don't have enough money to make the prototype, and it's the cart and the horse, what comes first. So they try to get the patent or a provisional patent, and then hopefully they can get some money to make the prototype, and then they find out the patent really isn't what they invented. So they have to go back and they have to change it. It's not a very good progression, because they go back. But if you can make a prototype, that's really what you need to do.
I think the truth hurts people, and they're an inventor they're passionate about their idea, they're passionate about their technology, as the case may be. But we don't mean to disappoint or hurt your feelings, but we're going to tell you the truth. And sometimes you just have a no-go situation. It's just not going to work. Or even if it works, it's just not going to go anywhere. And here's why. You make the call, you make the decision, but we'll do that research to help you. Think of it as due diligence. And again, it's covering the regulatory environment, the market, the business environment, and those are important things. Don't want to waste your time or your money. We're a good first stop shop.
Yeah.
Brian, go ahead.
Quickly over the FDA. I don't know if there are medical products involved here, but we have a book.
Before we move on, Dave did pose a question. Where is it desirable? Is it feasible and sustainable as a business entity?
I think that's a good tip for prospective entrepreneurs to ask, to make sure that they can answer that. When you go for outside funding, it's almost like greeting the devil's advocate. So if anybody's watched Shark Tank, they ask tough questions like that. So, sorry, go ahead with your comments about FDA.
Okay, FDA stands for Food and Drug Administration. And we have a guidebook that really is really quite good. Written by one of our adjuncts who's is an expert. He's not here right now, but he does consult with us. And it contains a lot of general and specific information about what it is and how to go about getting a product through FDA. And there's five sections. The first section is a general overview of the law, which is fairly old. And then it goes into medical devices, drugs, regulations for production, and food additives. We mostly work with companies making medical devices, sometimes drugs, but very rarely. Then it goes into different, what is a medical device? The different classifications, class 1, class 2, class 3. And everyone hopes they're class 1, which is low risk and the least amount of regulation. And usually they're class 2. And if you're really unlucky, it's class 3, which costs many millions to get through. Most drugs are class 3. And that's why drug companies charge so much, because it costs so much to get it through FDA. It goes through regulations of manufacturing regulations. What you need to know, many companies, very small entrepreneurial companies have a medical device and they want to produce it. And they have no clue about how much it's going to cost for FDA approval. And we try to give them that information because if you have a medical device, the best way is to license it to a company that knows how to do this and has the money to do it. We've had a few entrepreneurs that thought they could manufacture it, but they just didn't have the money to do it. So it's a great book, and it goes through very specifics on device classifications, product classifications, and basically how to work with the FDA on all those areas and what documents you need. You need to really control the documentation if you want to get an FDA product approved. And you have to have people, which is the biggest cost factor. You need people knowing the system, working with you, knowing what to do, what not to do. Otherwise, you're going to get really in trouble. So, I don't know.
I think the regulatory aspect of what we provide for inventors and entrepreneurs, FDA clearly, but there's many other regulations that we would look at. I remember we had one client that was taking plastics and making them into 4x8 sheet panels, originally designed for flooring in cow barns of all places, but it had terrific applications in marine as well as roofing material. And that was really where their market was. There were no specific regs on this reformed or recycled plastic in 4x8 sheets, but there were industry guidelines and industry standards that they were not aware of, but we were. And we were able to show them that if they made this into a roofing material or something for boats, here were the standards, and they were just caught totally off guard by that. That's good. Now's the time to do that before you go into production and before you spend millions of dollars trying to get to market. Interesting about FDA is that we know investors, they won't be put off. A sophisticated investor will not be put off by the fact that you're going to go through FDA, as long as you know what you're doing. And if you can show them your path to compliance, if you can show them your path to getting a 510K or whatever the case is, that investor, sophisticated investor, will put out their money, maybe even more so because you know what you're doing. And so that's the information that we try to provide serial inventors or entrepreneurs so that they at least make more sense as they potentially raise money.
Yeah, FAA is another example for the unmanned aerial systems, and the FCC is sometimes relevant. There's one on the export control regulations. When people want to export, they have to make sure that they don't need a special license from the government. So in addition to the regulations and the market, of course, really important aspect of commercialization, new technology is intellectual property. And um, Brian has a lot of information about that. And I think you're going to talk to us a little bit about that, Brian.
Sure, Molly. And just quickly for our guests on the line here, where can they find these guidebooks? They're on our website or?
Yeah,
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 I put the link in the chat box.
Okay, okay. All right.
Hi, Scott.
Howdy.
a friendly face right there. There he is.
So just to follow up on Molly said, we also have a guidebook on intellectual property. So earlier I was talking with Gary about patents. That's just one form of intellectual property. There's 4 primary forms, patents being one, trademark and trade name, trade dress are the second, copyrights, and then trade secret is the 4th kind. Within patents, you got a couple different variety of patents, a utility patent versus a design patent. Easy distinction there, as a design patent really gets you protection on the look of the technology. So, you know, typically we've done design patents for clients in different bottle designs, and contrast that with the other form, which is a utility patent. So that covers, you know, an article of manufacture, a method for making, or a business method type patent. The second category, trademark, just as the name suggests, it's how customers come to identify your technology through a name, slogan, or logo. They come to recognize that your product is of a certain grade and quality, and you can protect the name and right, or the name rather than the slogan, so that counterfeiters or other competitors can't either dilute or trade off of your trade name. Copyright, typically literary, artistic impressions, so sound recordings, so, you know, music, you know, books, scores, musical scores, things like that. And lastly, on trade secret, it's kind of akin with a patent. So in the event that you may not be able to get patentability, you may look to the trade secret route. A good example is you may not want to divulge to the public in a patent how you particularly make a product. You may want to keep that as a trade secret, but you might want to go ahead and patent the product, but you don't give away the secret sauce and how you make that product. So that's kind of how trade secrets and patents kind of go hand in glove. So those are the 4 primary areas. And so you want to think about all different types of intellectual property protection for your invention, for your company name, for your product name. There's a whole strategy around branding and marketing and protecting that goes along with the commercialization of your product.
Scott, the last time we saw you on one of these, you had a question that ended up being a summer project for one of our students. So
Yeah.
I'm a little hesitant to ask you if you have a specific
I'm going to
question.
put you on mute, Scott. That was challenging.
It was a good question, but
Just real quick, going back to trademarks, many of our clients come in and they already have their URL for their product or their company. That doesn't mean squat. It means you've got your URL. It does not mean you have the trademark. Doesn't mean that you're clear to use your word or your name. So that's one of the things we'll do. We'll do what I call a quick and dirty trademark search so that you know that you can stick with that name. It's an important thing to look right in the beginning.
yeah, and the law school does have a clinic too. You know, the quick and dirty is really useful, but what would the opposite be? prolonged and very thorough, clean.
It would be full search, full on search, all classmates. And
That's conducted by the Jessica Murray, who actually, it's an actual clinic, and they can file at the USPTO. It's difficult to get into, but if you know that that's something that you're interested in, we could refer you there.
Yeah, I'm saying I'm actually a student in the clinic. So we do all different trademark work and then also like not-for-profit work in it.
Yeah, you really learn. It's amazing the search terms, right, Caitlin? The way she breaks down syllables and everything, which
Yeah.
not Jessica, I guess that's the way it's done.
That it's done, exactly.
Mhm.
With different variations and different like I versus Y spellings and all that kind of stuff.
Mm-hmm.
Just on that topic, Caitlin, is it the URLs that are so hard to get, or is it the trademark that's hard to get that's inspired all these made up words for companies and products? Which
It's the
is-
trademark,
trademark is driving it?
for sure.
just generally speaking, I mean, we're not practicing law, nor do we give out legal advice, though Brian and I and Molly are all licensed attorneys. And Caitlin will be too one day soon. But the whole method of commercializing a product, a technology, is full of legal issues. The acquisition agreement, the distribution agreement, the licensing agreement, just the simple buy, sell, your own internal company, it can be overwhelming. But I think that we can, like I said, we can guide you or startup companies through that process and just say, you're going to need this. And some things, it's unfortunate, I don't want to pick on any lawyer or law firm, but they're going to oversell their services. Very often they're going to say, hey, we can do all this, and it's going to cost you $50,000. It doesn't have to be that way. You can do it in stages and steps. We can show you that this is fundamental documentation you should have as you start your business, and then eventually you get to someplace. But I think that's one place where we can, without offering legal services, will help you manage how you do use your legal services with a firm.
Yeah, that's such a good point, Jack, because we often explain to clients that most law firms, most IP attorneys can get you some kind of a patent, but you have to assess whether it will be a valuable patent, a strong patent. And maybe Dom, you want to talk about that kind of analysis you do with the students.
Yes, some entrepreneurs come with a patent and they want to know how strong it is. And they want to know if it's worth anything. And that goes along with what Molly said, that you probably can get a patent and you can make it very, very narrow. And usually narrow patents go through, because if you have enough elements in a claim, then it's very specific. And so it probably will go through. And usually those are not worth too much because it's easy to get around them. All you need to do is take one of the elements out and you don't violate that patent. So if you have 10 elements in a claim and you can make it with 9 elements, we take that one out, you can do that patent. You have to violate every one of the elements to violate. So good lawyers will try to make your patent as broad as possible, and then the patent examiner will try to make it more narrow. so it's a fight there, and depending on how much money you have, you can probably keep being persistent, and you can get a patent. And that's why big companies have a lot of patents, because they have a lot of money to throw at it. And entrepreneurs typically don't. And sometimes they give up. But you really want a broad claim to protect what you have. So that's no, there's Josie back there, just got up. So I think that's what you were talking about, Molly, right? It's trying to, and we look at patents and find out if they're strong, and there's a lot of different parts to that. The market is one consideration. You can have a great product, great patent, and if you can't sell it, it's really not a strong patent. So that's where Dave comes in with the market. He looks at that part of how strong a patent is. And then you look at if it can be, and there's a legal term, Brian, that when you have an opposition to a patent, it was well, I experienced where patent examiners will say, and you keep being persistent with them, and they will say, okay, I'm going to grant this to you and let it be fought in the commercial area. Let people fight it out. And if nobody fights it, then your patent is okay. But if someone fought it and found some prior art that invalidated your patent is worthless.
Yeah, that's an inter partes review.
That's right.
So a competitor comes before the patent office and says, Mr. or Mrs. Examiner missed these key pieces of prior art that would invalidate this patent. And it's just another another litigation proceeding, essentially, as opposed to being accused of infringement in a district court, federal district court. A competitor may, see this coming down the pike and be proactive and file this, what's called an inter partes review, challenging the validity of the patent.
Right.
I want to just say, Scott Hancock here from Binghamton runs their tech transfer and technology development at Binghamton. And it's interesting because a lot of the technology we see entrepreneurs have is university technology. And some universities are, how can I say this nicely, are terrible at it. But Binghamton is pretty good at commercializing and giving their licensees the opportunity to really be successful with the technology. So you don't even need to be an inventor. You can scour the tech transfer office sites of a technology available for licensing and just try to do that. But just you want to pick your education institution carefully and try to get someone in tech transfer who knows what they're doing and has a commercial sense for how your technology could be deployed into the marketplace. And then they would give you reasonable licensing terms as well. Scott,
yeah, that's a great point, Jack. We see more and more programs at universities that are pairing the business schools with the research side of the university, because it's really the business students that can take these technologies and run with them. Or Carolyn, like you were saying, you think of different ideas, you might find technology at a university that you could license out and move forward with. One other issue I was going to ask Brian about, it came up earlier, was the ways that startups sometimes don't realize they can really diminish the value of their intellectual property. You want to talk about some of those mistakes, Brian, with disclosure and things?
Sure. Let me see if I can be a little more eloquent than last time, I suppose, so Jack doesn't slap my hand. Yeah, we're on a webinar earlier with an early startup entity, and one of the things that they're putting together a checklist that they want to be able to tell their entrepreneurs and residents. And one of the things was, if they have a technology, and of course, in this era of social media and whatnot, everybody wants to promote. One of the issues that you can run into is making a disclosure around your technology without having filed for patent protection. And one of the things that can happen is, if more than 1 year has gone by from that enabling disclosure, and that's the key, enabling, which means it's detailed enough such that an engineer or scientist or some other person in that field of art could take your disclosure and create what then you seek to patent There's restrictions against that under the patent law that say that if you were to disclose that more than 1 year before filing for a patent protection, you've waived your right to seek patent protection and have now dedicated that technology to the public. So, you got to be careful that if you're, disclosing your technologies or writing papers on it, and obviously we want to encourage written discourse and scientific and engineering teaching and rigors. That's great. It's just if you want to file for patent protection, you better make sure that you're filing for at least what's called a provisional application, which can easily be a one-page document that you file with the patent office just to show that you sought patent protection before disclosing it to the public. And that way you're not running up against this 1 year bar date.
Yes, we sometimes have clients come and they show us their invention before there's an NDA in place. And so it's an important thing to be aware of. And people can sometimes be uncomfortable asking other people to sign an NDA. And I guess the way around that is, like Brian said, you don't disclose the enabling elements of the invention. Well, I don't know if anyone has any other questions or anything. We intend to do this every third Thursday of the month, and we're going to gather the questions we get in other situations, and then we'll just pose them at our next session. Or if you want to send one in, we could talk about that too.
One of the beauties of Zoom is that we have access to a network of wonderful people, including Mr. Hancock down there from Binghamton, but we have others that if someone had a particular question, we could actually bring the expert, our subject matter experts, our friends, if you will, on here. That's one of the nice things about Zoom. It's unfortunate we can't be personal in place, but this way we can actually bring on people, including attorneys who do practice law, that can offer advice. So if someone gives us questions ahead of time or wants some general subject, an expert, we can do that.
Yeah, and it will be the same Zoom link, right, Carly?
Yeah, I was just typing back. So it'll be the same Zoom link. I will update the page. I don't know if you accessed it through the page, but I'll update that too in case you lose the Zoom link, but it will be the same one, yes.
So if I know I came late, I apologize. And I heard the tail end, I guess part of the discussion was about trademarks and for companies and product names. It just so happens, it's not planned, that we're trying badly or poorly to help a little spin out company come up with their name, because they got to get moving and get certain registrations done, et cetera, and go after some SBIR funding. So they're trying to, get things lined up properly. And we do amateur, right? We do the test checks and things like that, but and the URL checks, but I know there's a lot more to it, and to have a strong name. So I was really intrigued to hear at the end that you said, is it a Professor Jessica Murray in the law clinic, and Caitlin is in the class at this time? Is that something, because Tech Transfer Office really doesn't need to be telling people how they should name their company, I don't think, but is that something we can refer them to?
Absolutely.
Yeah, so right on the USPTO website, even there's a link to all of the clinics that they offer, and you'll see the Syracuse one, and then that'll send an email to Jessica, who's in charge, and she monitors that periodically, and we'll get back whether or not they meet the requirements, because obviously it is a free clinic through the school. You have to meet certain requirements in it, but that'll send that to Jessica, which is all the administrative side of it.
Yeah, I had actually stumbled across that on the USPTO main website maybe 3-4 months ago. I was really quite intrigued that they do offer services. I guess it was a means test And that there's a roster of entities that can provide that. It's really something. I didn't know if that, overlapped. I still call your group, Jack and Wally, NYSTTLC, but, and I know you don't give legal advice per se, so I don't think you would actually do the filings, right, in that same way. Yeah.
Right, right.
We're in the clinic as student attorneys. We're working under Jessica's law license. So we actually do all the filings and everything.
Awesome.
So like right now I'm working on a renewal for another client. That's like her 10-year renewal of the trademark.
Yeah, go ahead and to encourage them to apply, because I don't think it's just based on means. I think that's a factor if they have to make a choice, but.
Absolutely. And obviously trademark clients are easier to take on. Because it's like you said, from tech transfer, we do primarily people that are in upstate New York and New York State. But trademark clients don't have to meet as many of the requirements as like our not-for-profit clients do. So.
Thank you.
Yes.
Okay, well, until next time. Does that make sense?
Good.
Thank
And
you.
we have these recorded, so we'll always post them. Go back if you forgot.
Well, after we listen to it and make sure we want to post it.
We might learn
Fact
something.
check.
We might learn something, right?
Are we done?
Oh, actually, can I? Oh, okay, never mind. Okay, thanks very much.
Thank you all.
All right, bye-bye.
Appreciate it.
Bye, everyone.
Thank you.